Hi, y'all, and welcome to the live stream. Brian Kohberger is currently sitting in jail in Idaho, accused of murdering 4 University of Idaho college students. They were attacked by a knife-wielding maniac in the middle of the night as most of them slept. They were all 4 college students, and according to prosecutors, the person wielding the knife was Brian Kohberger. He was a supposedly mild-mannered university graduate student attending a nearby university. So now Brian Kohberger says that the court ought to dismiss the indictment against him, that the court ought to just put it aside and say it's no good. It's not a surprise, of course, that he would want out, but the reason he wants out, now that's a little bit of a surprise, and that's what we're going to talk about tonight. Does he have a shot at getting his motion to dismiss the indictment against him actually granted? Is that even a chance? We're going to talk about that, and we're going to talk about what he's asking for. And I'm going to give you my opinion about whether he has a shot of getting out based on this motion to dismiss. Now, remember, he also claims he has an alibi. We talked about that in a prior video, and I'm going to cover the state's response to his notice of alibi that he filed earlier. They're responding just as I did in a video. Now, we meet on Monday, Wednesday, and Friday at 7 p.m. to talk about all the cases that you're talking about to make them more understandable. Coming up on Friday and then next week, we are about to have 2 of the most interesting videos that we've ever had. I'm going to stick around the end and I'm going to tell you a little bit about them, but be sure to hit that subscribe button because you don't want to miss it. And while you're down there hitting subscribe, hit the like button too on the video. It'll get it out to more people. So also, if you would follow me over on Twitter at LawyerLeeW. I'm posting a lot more to try to keep up with all of the legal news that we're trying to cover. Now let's start with the motion to dismiss that Brian Kohberger's team filed. It was beautifully written, beautifully researched, but very technical, very esoteric, difficult to follow. So is to make it really simple and brief. I'm going to talk about what Brian Kohberger is asking for. I'm going to talk about why he thinks he should get it. And then I'm going to give you my opinion on how likely he is to win and to get the indictment against him dismissed. So we'll talk about those 3 topics. And then we'll get into the alibi. But for this topic, we're going to cover those 3 areas. So let's start with what Brian Kohberger wants and why. To help you understand that, I need to give you a little bit of context. The grand jury indicted Brian Kohberger. A grand jury is a group of citizens. It's like a trial jury, but has a different way of operating. So the grand jury is usually more than 12 people. Usually a jury is 12 people or even fewer in some states, especially with civil cases. The grand jury usually lasts a pretty long time. It's a significant sacrifice for a citizen to serve on a grand jury because it usually does last for a while. And most importantly, probably of all, the grand jury doesn't hear from both sides. The grand jury listens to the prosecutor. The prosecutor comes in, presents testimony, presents evidence, and then that evidence is voted on in secret by the grand jury. So the grand jury will talk about what they've heard, and then they'll do a vote. Now, are they voting on guilt or innocence? No, not like a trial jury. What they're voting on is probable cause. Is there probable cause for the state to charge the defendant with these particular offenses, with these crimes? Is there probable cause to believe this defendant committed these crimes? That's what they're looking at, not guilt or innocence like a jury would look at. And remember, they are only hearing from one side. There's an old expression lawyers talk about, could indict a ham sandwich. And what that's meant to say is getting an indictment is way easier than getting a conviction because the standard's different. Probable cause instead of beyond a reasonable doubt. So it's much easier to indict somebody than it is to actually go through a trial and convince a jury of the guilt or innocence of beyond a reasonable, I shouldn't even say guilt or innocence, of beyond a reasonable doubt. So there is an alternative to a grand jury indictment, and that's an alternative is a preliminary hearing. Now, it has the same purpose, which is making the decision about whether charges should go forward against the defendant. But the method is very different, because the method with the preliminary hearing is that both sides come, the defense gets to be present. The defense lawyer gets to cross-examine the state's witnesses. In some cases, the defense would get to put on witnesses, particularly, for example, if there's an alibi. So the evidence then is seen, and the defense gets to know what it is, gets to argue against it, and argue to the court about whether or not the case and the charges can move forward. Generally, a defendant would want a preliminary hearing, and because of the chance to participate in it. Frankly, so would the public for the most part, because it's public. And so we learn a lot more about what the issues are, about what the case is about. So that's the context. Now let's look at what Brian Kohberger is asking for. He has filed a motion to dismiss the grand jury indictment against him. So there was a grand jury, he was indicted, which would mean no need for a preliminary hearing, right? So he has two goals, and let me show you. I'm going to share my screen with you so you can see what he's asking for. He's saying that he wants an order either dismissing the indictment in this matter, or to treat it, skip that, and treat it as a presentment and remand for a preliminary hearing. So he wants one of two things. Either the grand jury indictment gets dismissed, or he gets that preliminary hearing where he gets to hear the evidence and his lawyers get to cross-examine and kind of test out what the evidence would be. And the grounds for it, he says right here in this first paragraph, is that the grand jury was misled as to the standard of proof required for an indictment. So let's get into what he's talking about. So that's what he's asking for. He's saying, I want this whole indictment dismissed. In that case, by the way, the prosecutor can bring it again. The prosecutor can go back to, may have to wait for another grand jury, but the prosecutor can go to the next grand jury and say, I want to indict him. What the defense is wondering about is whether or not they'll be able to outwait the prosecution, go long enough that it takes too long, or the prosecution gives up, or maybe the new grand jury won't indict. So all of those things are a hope. Or on the other hand, a preliminary hearing, that would be great too. Brian Kohberger is asking for either one of these. So let's take a look at what his argument is. And we're going to pull up. He argues that the Idaho Constitution sets the standard of proof for beyond a reasonable doubt. Now, that's the exact same standard of proof that a jury would have. That's the defense argument. I'm not saying that is the standard. I'm saying the defense argument is that the grand jury ought to be using the exact same standard as a trial jury would, beyond a reasonable doubt. Has the prosecution shown beyond a reasonable doubt that Brian Kohberger can be convicted for these particular crimes that he's charged with? The defense is saying what the jury was told instead was that all they had to look at was probable cause. And the defense says that's too low a standard. That's not fair. It should be the same standard that the trial jury looks at. The prosecution argument is probably going to boil down to, well, why would we do that? That would just be having the trial twice. We would have to convince the grand jury beyond a reasonable doubt, and then the trial jury beyond a reasonable doubt. Why would we do that? That's doing the same thing twice. And I think the defense would say, yeah, that's what it's supposed to be. It's supposed to be two chances at getting out. And that's what the Constitution called for. So let's go through the defense argument, and then I'm going to definitely summarize parts of it. So what they say is that back when the Idaho Constitution was adopted, that Idaho had a standard, and at that time, it had a statute, not a standard, a statute, and it said the grand jury ought to find an indictment when all the evidence before them, taken together, if it unexplained or uncontradicted, would, in their judgment, warrant a conviction by a trial jury. So they're saying if they're looking at what it would take to get a trial jury to convict, they should be using the exact same standard. And now I'm going to pull out of the document and just talk about it. Now, this is not because it wasn't well written. It was well written, but it's very technical. And I think a little bit difficult to understand. So let me pull back out a little bit and talk to you a little bit about what he's arguing here. So essentially what he's saying is that long ago, when this was first enacted, the standard for the grand jury was supposed to be, always was supposed to be, that the grand jury would use the same standard that a trial jury did. And that it got screwed up somewhere along the way. In fact, they can tell you when and where. They say it was all New York's fault. If you're from New York, it's your state's fault. That back in 1850, the New York Field Code of Criminal Procedure abandoned what had been the rule and suddenly switched to this probable cause standard. And the defense is saying that this spread like a virus through courts all over the country, including in Idaho. And the idea that the grand jury only needed to find probable cause became the standard everywhere. But it should never have been the standard. Now, does this make any difference? Let's talk about that in two different directions. One in practical terms, and then one in this case. So in practical terms, the difference would be with the standard of probable cause. All the grand jury is saying is, we think there's probable cause to ask a jury whether the jury believes that the defendant committed the crime beyond a reasonable doubt, could be convicted of it. Versus we, the grand jury, believe that we ourselves are convinced beyond a reasonable doubt that this defendant committed this crime and could be convicted by a trial jury. Does it make a difference in this case? Well, the difference would be that the grand jury in this case was instructed for the standard that is typically used, the standard that is, we believe that the prosecutor has probable cause to bring this case against Brian Kohberger. Because the jury was instructed just the way every other grand jury is in the country, they say that was wrong. The entire indictment has to be thrown out. So we either get a new shot at an indictment or, and the prosecution has to start over on getting an indictment or do a preliminary hearing. One of those two things. Now, is that argument any good? Let's go ahead and analyze that. And I'm going to talk about that. I'm going to show you what they say about their own argument in the document, okay? Hold on one second. My document flipped to a brand new document, not the one I was talking on. Sorry about that. So here's what they say in the motion to dismiss. We'll go ahead and make it a little bit bigger again and talk about what they say. They say, here we go, I'll put it in green. So the defense recognizes that the whole of modern jurisprudence on this issue is against it, as well as at least one founding father of this state. In other words, I mean, this is a very broad statement. The whole of modern jurisprudence, all that writing on law is against what we are arguing here. We admit that. We admit that, court, that what we're saying here is not what everybody else thinks the standard is. We think we're right, but this has a lot of integrity. It's a very ethical way to say it, to say, we believe that this is wrong, but we want you to know this is what the law is and what the law has been. We don't want to hide this from you so that you make a decision without knowing. We want to be honest about that. So I do respect that. And they also say, we'll keep going for more green down here, that they acknowledge that the Supreme Court itself of Idaho adopted a rule, Idaho Criminal Rule 6.5a, that says the grand jury ought to find an indictment when there is probable cause to believe the defendant committed the offense. So the actual rule by the Idaho Supreme Court says the standard is probable cause, not beyond a reasonable doubt, not the same standard that a trial jury uses. It's a much lower threshold. And then final thing they say in here, acknowledging again what they've said, they say over 150 years ago, Idaho joined the state of California in adopting the Field Code. That's the one I told you about, thereby adopting reforms to the grand jury system intended to restore that system to its function as a bulwark for freedom. The strange history that follows in this state, just as every other state with the same statutory scheme, is both tragic and unconstitutional. So they're saying every state has gone with what Idaho has. Every state has gone with this probable cause. No state says that the grand jury needs to make a decision using the same standard that a trial jury does. Nobody says that. And Mr. Kohberger is asking this court to recognize the long string of error that led us here and give back the people of this state the protections they are owed. So they are fully acknowledging that that everything they're asking for is not permitted under the law. They're saying that openly and honestly. This is not the standard. This is not the standard being used in any state. It's not the standard being used by the Idaho. It's not the standard promulgated by the Idaho Supreme Court. This is what they think the law ought to be, but it is not, in fact, what the law presently is. So that's what they're being honest that that's exactly what's being said. This is, in other words, a hugely uphill battle for them. They are having to argue that 150 years of precedent should be set aside in this, in every other state, by the Supreme Court of Idaho. They're asking the trial court to say all of those courts, the Idaho Supreme Court, everybody has gotten it wrong for 150 solid years. So why would they file this? Because it does seem like pretty much a difficult standard to meet, to say the least. I can't really answer that. They must be hoping that one day the Idaho Supreme Court, courts throughout the nation will wake up and realize what they think is the case, which is that this all got off somewhere. It's all been incorrectly decided, and the precedent of years and years should be set aside. It's not fair. But meanwhile, I am going to have to give this the first ever Harvard Lawyerly Channel Snowball's Chance in Hell Award. Zero chance I can see that the trial court would ever grant this motion. I think it would be impossible for a trial court to grant it, because the trial court would have to say the Supreme Court, which I'm supposed to follow, is wrong. The Supreme Court rule is wrong. And I don't think that the trial court has the power to do that. I think it would be extremely difficult for the trial court to do that. So now there are two other important developments that I want to talk about in the case. Let me remove that for just a minute. The first is that anybody and everybody is putting a whole lot of stuff under seal. The state's response to the 5th and 6th supplementary requests to discovery, they moved to seal their exhibits. The defense, for this particular motion that we just talked about, asked to file their attachments under seal. That was granted. The first one was granted temporarily until a hearing can be held. And then the defendant filed a second motion to stay proceedings and asked that the affidavit attached to that be kept under seal. So a lot of stuff we aren't finding out about because it's being put under seal. That's important because every single time it happens, we miss some information. What information? We don't know, but we know we missed something. Now, the next topic I want to talk about briefly is the state's motion to compel Brian Kohberger to say what his alibi is. And we talked about that in a video. I am not able to link something until YouTube has processed the live video. So as soon as I can, I'll link that video I did earlier where I talked about Brian Kohberger's alibi. And I talked about what an alibi is supposed to be. An alibi is supposed to be where you say, I was somewhere else doing something else and everybody knows it, or somebody knows it, a witness, or at least I can tell you where I was. I could not have committed this crime because I was somewhere else. That's what an alibi is supposed to be. And that's not what Brian Kohberger's motion said. The state agreed with that too. So they filed a motion to compel the alibi. What they've said is, and let me add it to the stream. I'll switch over to that for you. So they've asked the court, they said, look, what they filed, that wasn't an alibi. That was just a, hey, in the future, we might tell you an alibi sometime. They said, we have the right to actually hear what the alibi is, to know what it is that Brian Kohberger says he was doing that proves he could not possibly have committed this crime. If he's got an alibi, we need to know what it is. And they say, they go back to the code section as we talked about, and they said he's supposed to give specific place or places that he claims to have been at the time that the murders were committed, and he's supposed to give the names and addresses of the witnesses who will corroborate that that's where he was, that he couldn't have committed the crimes. He says, and the state also argued he's not complying with the Idaho statute because he's got to be specific. He's supposed to do those specific things so we know what to do. And one of the things Kohberger had said was, I have the right to remain silent. The state said, your right to remain silent is not the right to hide facts that support you. And you can picture what might happen if the state didn't have the right to hear what the alibi is, which is the defendant stands up in court and says, well, I couldn't possibly have committed it because I was across town, and we covered this in the video, but I was across town, leading a group of bishops in prayer, and all of 50 bishops will gladly testify that I was there. And the state has absolutely no way of getting in between that and determining whether or not it's true. They don't have any way of proving that the thing that was said was false. So the state says, okay, yeah, you've got the right to remain silent, and you have the right to call witnesses, but you've got to tell us where you're headed. We have a legitimate interest in learning what the alibi is and being able to respond to it. And what you produced was not an alibi. It wasn't what the statute and what the rule call for. And they point out jury trial's just barely over 2 months away. We need to be able to prepare. We've got to be able to do that. They say, we don't have any way to prepare because we don't even know what your alibi is because you didn't say, I was here, I was there, so-and-so saw me, nothing. You gave us no idea of what you were going to say. So what they've asked is for a couple of things. One is for the court to tell the defendant they have to comply within 10 days. You got 10 days to comply. And if you don't, then, and they say, otherwise, that the state be allowed to provide, let me back up. So they say, we want you, the court, to tell the defendant that within 10 days, the defendant has to give us a real alibi. And then we have time to respond to that because we need some time to look into it. Normally, the state would have to do that fairly quickly. They say, we want you to give us up until 10 days before trial to do that. And then they say, alternatively, we would like you, court, to prohibit the defendant from presenting any evidence, whether it be in support of the claimed alibi or whether it be witnesses who would support that, whether it be some kind of facts that would support it. We want you to prohibit the defendant from introducing any evidence about that alibi because he hasn't disclosed it. So what are the chances that the court is going to do that? Second, very, very slim, I think. The court's going to be very reluctant to eliminate an alibi in a quadruple murder capital case where the death penalty is on the table. I think the court is going to be very reluctant to do that. But I think the court probably would say, yeah, that's really not complying with the statute. You're really supposed to be a lot more specific than you were. You weren't specific at all. We have no idea what you think your alibi is. So now we have a hearing coming up in the Kohberger case on August 18th at 10:30 a.m. The last hearing was pretty brief because the parties had worked things out beforehand. Who knows what it'll be this time. Excuse me. But I want to give a quick channel note, and then I'm going to tell you about those two upcoming videos that you absolutely don't want to miss. So let me pull this out of the screen. Oh, wait, let me not pull that out of the screen because there's still something I want to show you in there. So I asked the question on our community page. I said, I haven't been doing anything political because it's political. But some people have said, we'd really like to hear more about that, Lee. We'd like to learn a little bit more about what these cases are about. And you could explain that. Why don't you cover some of these things? So I put it out to the group and I said, all right, what's your opinion? And I think y'all felt about it pretty much the way I felt about it, which was split as to whether you wanted to hear any of it. But if you look into the numbers, 44% of you said that 44% said you didn't want to hear about Hunter Biden or Donald Trump. So that's a pretty big group. And now you were given the option of Hunter Biden and Donald Trump. And 22% of you picked that. But 18% picked you wanted to hear about Hunter Biden, which means you didn't want to hear about Donald Trump, because that would have been an option you could have picked. So what I'm looking at is 62% of you didn't want to hear about Donald Trump at all. And 60% of you didn't want to hear about Hunter Biden. You didn't want to hear about that at all. So I think y'all are somewhat divided about it, but the bigger number, the bigger percentage, are not really interested in going that direction. So I'm not going to get into that, certainly on our live streams. I may do some extra videos on those topics, but I'm not going to change our live streams. We're going to keep going with our live streams just as we've been doing. And thank you. We had a huge response. We had about 3,000 people answer that. So thank you very much. It really helps me a lot for you to give me the idea of where you want to go and what interests you. That's really useful to me. Thank you for answering. So coming up, we have two of the most interesting videos I think that the channel has done, period. On Friday, I'm going to be interviewing and talking to Travis Jenkins. He's the reporter from South Carolina who broke the story about the South Carolina search warrant. He actually got the search warrant. We talked about that on another video. It's critically important for several reasons. And I know for those of you who have been following along, you know what I'm talking about. I'm talking about the Rex Heuermann case. He's the person accused of being the Long Island serial killer or the Gilgo Beach serial killer, or at least one of them. He's accused of 3 murders, chief suspect in a 4th murder of the 11 bodies found along a deserted beach highway near Gilgo Beach in Long Island. A search warrant was executed against a car and against the brother of Rex Heuermann, and that brother lives in South Carolina. The search warrant was extremely important because it gave us 2 things. First of all, we could see that the police were trying to find the Chevy Avalanche, which apparently had been given by Rex Heuermann to his brother Craig and was now in South Carolina. The second thing it did was it showed us what the defense, what the prosecution was looking for in the search warrant that most probably was copied over from the one in New York. So it was extremely useful on several different levels to help us understand where the prosecution is going and what law enforcement is looking for in that case. So Travis Jenkins is the one who found that search warrant, first got the copy of it. And I'm going to be talking to him about what exactly law enforcement has been looking for in South Carolina. Is there any evidence that they're suspecting that there were other murders in South Carolina? Is there any evidence of conspiracy? Is there any evidence that they went beyond the Chevy Avalanche and looked anywhere else in South Carolina? So I'm going to be asking him what he knows about how law enforcement is reaching out. They've specifically said that they'd be crazy not to look elsewhere to see whether or not there were other people murdered by the person they believe is Rex Heuermann, killed these 3 women and probably a 4th. So they've said we're of course going to be looking elsewhere. That's what I want to find out about, is what they're doing in South Carolina. So we're going to be talking to Travis Jenkins about that. Then next week, at your suggestion, thank you, we're going to be talking to John Ray. He's a New York attorney for many years now, has followed the Gilgo Beach serial killer case, and he represents 2 of the families of victims found along that stretch of Beach Highway. Now, Rex Heuermann has not yet been charged with murdering the two women whose families John Ray represents. John Ray has always believed at least one other person was involved. He personally has believed that probably a woman was involved. We're going to be asking him about that, about the investigation, about what his client is thinking about Rex Heuermann as the suspect. Is that someone they believe could be involved in the murders of their loved ones? We're going to be talking about all of that. So be sure to hit the like button for this video if you would, and don't forget to hit the subscribe button, because these two videos are going to be super interesting and you definitely don't want to miss it. So I will see you Friday at 7 p.m. We meet, I'm losing my voice. We meet Monday, Wednesday, and Friday at 7 p.m. Eastern. So I will see you next.